May I request Mr. Amarjit Singh Chandok sir, Mr. Amit Desai sir, Dr. Uday Prakash Varenjekar, Mr. Sujit Kumar, Honorable Member of Parliament, Mr. Siddharth Dhabe, Senior Advocate, and Dr. Anindita Pujari to come over to the dais. Dear friends, we are going to start this session on Bharatiya Nyaya Sanhita 2023 issues and challenges. Next couple of years, all of us will be facing the challenges in the court hall when we plead the cases. Today, we have with us the chairperson of this meeting, Mr. A.S. Chandyok, who was the former Additional Solicitor General of India, was also the former president of the Delhi High Court Bar Association. He is also the president-elect of the Bar Association of India. We have with us Honorable Member of the Parliament, Mr. Sujit Kumar. Mr. Sujit Kumar is a software engineer turned lawyer who also practices there in the Supreme Court. He has also got a law firm in the state of Odisha. He was working in the capacity, a rank of the Chief Secretary in the Special Development Council. Being a part of the Select Committee, he was also hearing at the formative stage about this Bharatiya Nyaya Sanhita. So we thought that he would be with us, and we invited him, and we are glad that he is with us. We have with us Mr. Amit Desai, a leading criminal lawyer of the country. Mr. Desai was a part of also of the Maharashtra government in terms of being a special public prosecutor, special counsel in many of the matters, and he is an authority in the area of criminal law. So we are extremely glad to have him with us in this session. We have with us Mr. Siddharth Dhabe, Senior Advocate of the Supreme Court of India, amicus curiae in different matters, and I was also thrilled to know that he is also from the same alma mater, National Law School of India, University Bangalore. So I was just thinking, what a correlation today that Siddharth, me and Anindita, we are there in the dash. We were all students of National Law School, and also at the same time, Anindita, me and Sujit, all three of us are there as we are from state of Odisha. And I am very happy to tell you, we have also with us Dr. Uday Varenjekar. Dr. Uday Varenjekar and me, both of us have one thing in common. We also represent the Bar Council. So we represent the community, but what role are we playing when it comes to these kind of issues and challenges? That's also important questions all of us need to think in terms of what is the role of the Bar Councils actually as a regulatory body, what are they doing. So now friends, over to Chandyok sir. He will start and initiate this dialogue, and then we'll go to the other speakers. Over to Chandyok sir.
Thank you, Mr. Tripathi. After saying that you and my friend Uday both represent Bar Council, so I thought Bar Councils of India and Bar Council of State must take lead now to tell us about these three acts and probably do capacity building. And I'm sure you're doing what you're doing. We have an interesting session of what we have penal code earlier going into a new domain now. Probably we'll have to rethink as lawyers. Of course, our experts will tell us how to sail through it easily. Mr. Desai and Lavif especially. And of course, Mr. Sujit Kumar will tell us why did they enact that. I'm just giving an example. We have now introduced the section 106 because the run and hit is a common feature that we saw in this country. So a new provision has been made there. We have carried out amendments which we have carried women and children in one category. We have seen how we can bring as priority situations in our penal code. There are certain welcome changes in the enactment, there is no doubt about it. But how do we implement it? Law is always there, but how do we implement will take its own course. How do we react to it? How lawyers will interpret it? How courts are going to ultimately interpret this situation is yet to be seen. We still have a few months to acquaint ourselves as to what we will do, but these experts will certainly explain to us what are the new domains we have to meet, new challenges that we have to meet, and how do we take aid of the law laid down so far with respect to this act, especially the penal code. We'll have other sessions tomorrow with respect to other enactments also. So without taking your time on this, may I invite first of all Mr. Amit Desai to say in what manner should we meet this new challenge, what is the capacity of this act, how does it, what is the preamble, how does it go about, what is the framework of these different chapters, and how do we react to it. Amit.
Well, first, thank you for the Bar Association to invite me, and of course, I think we'll need many more sessions on these three legislations, considering all the various nuances that have been now introduced. So, ladies and gentlemen, today, as we stand on the precipice of the new Bharatiya Nyaya Sanhita, it is imperative that we delve into the annals of history to understand the journey that has led us to this pivotal moment. The roots of our legal system, deeply embedded in the history of India, stretch back to the 19th century, a period marked by significant transformations, upheavals, and the birth of ideas that would shape the course of our national legal landscape. Between the years 1833 and 1862, India witnessed a tumultuous era characterized by colonial rule, societal change, and the gradual awakening of the nationalist sentiments. It was during this time that the Penal Code, a cornerstone of our legal framework, came into existence. To comprehend the genesis of this monumental legislation, one must first grasp the historical backdrop against which it emerged. The early 19th century saw India under the governance of the British India Company, a period marred by exploitation, economic policies favoring the colonizers, and the erosion of the indigenous systems of governance and justice. However, it was also a time of intellectual ferment, with the seeds of reform and resistance taking root amidst the prevailing turmoil. The penal law and procedure varied from princely state to princely state and from presidency to presidency, with differences in the punishments for the same offense, to acts being offensive in some areas but not in others, or ingredients being different from place to place. Central to the formulation of the Penal Code was the establishment of the first Law Commission of India in 1834, tasked with the monumental responsibility of consolidating and codifying the laws of British India. Led by luminaries such as Lord Macaulay as chairman, the commission had four other members, namely Cameron, Macleod, Anderson, and Millett. The first three members represented Madras, Bombay, and Calcutta, respectively. The commission was assigned the task of codification of the laws. Based on a simplified codification of the law of England at the time, elements of the Penal Code were derived from the Napoleonic Code and Louisiana Civil Code of 1825. Lord Macaulay thought the basis for such a code should be, and I quote, uniformity where you can have it, diversity where you must have it, but in all cases, certainty. He also felt that such a code was the only blessing which an absolute government is better fitted to confer on a nation than a popular government. The members of the commission prepared a draft penal code which is submitted to Lord Auckland, the Governor General, on the 2nd of May 1837. It could not be immediately enacted into a code as there was confusion in relation to the substantive civil laws and the laws of procedure and various other reasons. Multiple Governors General of India felt that reforms were not needed and opposed the new law. The IPC project was delayed by the governmental and legislative inertia, resistance by European residents to having the same legal status as indigenous populations, and the loss of reforming momentum in the metropole. The first final draft of the IPC was submitted to the Governor General in 1837 and was drafted and redrafted until finally the draft then underwent a very careful revision at the hands of Chief Justice Barnes Peacock, who became a member of the Governor General's Council in 1852. The year 1857 stands out as a watershed moment in Indian history, marked by the Sepoy Mutiny, also known as the First War of Independence. The uprising, fueled by grievances over colonial exploitation and cultural insensitivity, underscored the simmering discontent beneath the surface of British rule. Although the war was eventually quelled, its reverberations echoed across the subcontinent, galvanizing the nascent nationalist movement and laying the groundwork for future struggles for independence. Soon thereafter, the indigo farmers' revolt erupted, primarily in the Calcutta region, which was then the capital of India. The revolt of 1815 was a movement of peasants and farmers against the British planters who forced them to cultivate indigo instead of other crops on their land. Indian farmers were frequently oppressed to cultivate more crops. With the 1857 revolt as well as other uprisings came brutal reprisals that fundamentally shook British claim of enlightened rule in its colonies. Following this, when the British Crown took over the reins of India from the East India Company in 1858, it felt that such a law was necessary to quell any future rebellions and punish the locals as per British law. According to one scholar writing on Macaulay, the English political classes saw the legitimacy of British rule founded on the claims of constitutionalism and the rule of law undermined by such repressive responses. Enactment of the IPC helped to address these concerns. The IPC came to be passed in October 6, 1860, effective 1862, as a reaction to the events referred to above, heralding a new chapter in India's legal history and ushering in an era of codification and consolidation under British colonial rule. With the establishment of the Chartered High Courts on June 26, 1862, the dominion of law and judiciary over the entire territory was extended across the length and breadth of the subcontinent, cementing the authority of the colonial state and paving the way for the enforcement of legal norms. And amidst the tumult of the 19th century, visionary leaders such as Bal Gangadhar Tilak, Mahatma Gandhi, Jawaharlal Nehru, B.R. Ambedkar, and various others were born. Their indomitable spirit and unwavering commitment to justice and equality served as beacons of hope in a dark and oppressive era. Now, in contrast to the 19th century milieu characterized by colonial dominance and traditional modes of justice, the 21st century has witnessed a seismic shift in the legal landscape, propelled by technological innovation, globalization, evolving societal norms, and a strong judiciary with visionary judges. The Supreme Court in the last 75 years infused the penal code with constitutional principles under Article 21 and elevated principles of fair investigation and trials to a fundamental right. Though there have been various amendments from time to time, there has never been a substantial overhauling of the penal code. The law made in the 1860s has stood the test of time, making it the longest surviving code in common law world, perhaps a testimony to how well thought out it was at the time of its creation. However, alongside these remarkable advancements, the post-independence 20th century has also witnessed emergence of new challenges and complexities ranging from crimes against the economy, organized crime and terrorism to gender-based violence and sedition. The need for robust legal frameworks underscoring the imperative of legislative reform and innovation in pursuit of justice and security for all, as indicated by several specific legislations were promulgated to deal with the emerging offences of that time. It is against this backdrop of historical legacy and contemporary imperatives that we must examine the significance of the new Bharatiya Nyaya Sanhita. building upon the foundations laid by our forebears, this trinity of legislation, which we are discussing tomorrow also, to reconcile it with the exigencies of the modern age. The use of technology for the purpose of investigation as well as in the process of judicial proceedings has become critical in the last few years. The proliferation of technology has revolutionized every facet of the justice system, from legal research and case management to forensic investigation and dispute resolution. The use of artificial intelligence, big data analytics, and blockchain technology holds the promise of enhancing efficiency, transparency, and access to justice, hopefully heralding a new era of legal empowerment and accountability. The advent of new legislation such as the GST, the data protection laws, the IBC reflects the changing contours of governance and economic policy in a rapidly transforming world over the last few years. And also with the changing landscape of the number of prosecutions under special legislations, it is possible that the government has taken into consideration some of the changes in the tapestry of offences, for which we will hear something from our learned Member of Parliament. Now, for example, in 2003, the number of prosecutions under TADA and POTA was 325. This is all NCRB data. And the number is now at about 1,000 under the UAPA. With offences like sedition, which had caught the imagination of the nation with the trials of Bal Gangadhar Tilak and Mohandas Karamchand Gandhi having become less relevant in the post-independence era, its misuse as a political tool to prosecute persons critical of the government and its policies, there has now been a reduction in the number of prosecutions relating to sedition in 2022. Now, coming to the penal code itself, on a simple textual comparison, it is evident that a large portion of the IPC has been retained verbatim in the BNS. The introduction of new offences and the importing of offences from other legislations with some changes and deletions of IPC offences have important implications that need to be assessed. 511 sections of the IPC have now become 358 sections. Only about 17 new offences are added, 9 of which are by way of subsections to the existing sections. 144 sections got amended largely due to increase in punishments, and about 198 sections have remained unchanged. The numbers have reduced primarily due to combining and reorganization of section numbers, and further a total of 14 offences and 5 definitions have been deleted. But dealing with some of the important changes, because it's impossible for us to go through the entire legislation, I chose to pick up a few by way of an illustration. One of the new offences introduced in the Sanhita is the offence of terrorism. Section 113 of the Bharatiya Nyaya Sanhita has introduced the offence of a terrorist act. Presently, offences relating to terrorism are dealt with under the UAPA. The offence under the BNS is identical to the offence under the UAPA, and we will hear more, I hope, from Mr. Kumar. Interestingly, though, BNS recognizes life imprisonment without parole. The Parliament has chosen not to introduce this punishment as a punishment for a terrorist act. The only distinction is that under UAPA acts and organizations which are recognized under international treaties and which are included in the act and notified under the UAPA would be considered as terrorist activities, but those class are not included in the BNS. There is no clarity as to why these parallel provisions are made to coexist, because the repeal and saving doesn't repeal the UAPA. Though the explanation to the section provides that an officer not below the rank of a superintendent of police shall decide whether to register a case under this section, that is the BNS, or under UAPA, there is no clear reason as to why it would be decided and to which statute, and why the power is given to the superintendent of police to decide whether to invoke the BNS or it's a matter which should go to the UAPA. Though the Supreme Court in Hitendra Thakur indicated that terrorism extends beyond the effect of an ordinary crime, which is capable of being punished under the ordinary penal law of the land, its main objective is to overawe the government or disturb the harmony of society or terrorize people and society at large, not just those who are directly assaulted. The fallout of the intended activity must exceed the capacity of ordinary law enforcement agencies to tackle it under the ordinary penal law. Yet, a specialized offence has made its way into the general criminal law, which is the BNS. What distinguishes terrorism from other forms of violence is the deliberate and systematic use of coercive intimidation. Often a hardened criminal takes advantage of the situation and by wearing the cloak of terrorism aims to achieve acceptability and respectability in society. It is therefore necessary to treat such criminals differently than an ordinary criminal capable of being tried by ordinary courts under ordinary penal law of the land. While the crime committed by a terrorist and an ordinary criminal may overlap, it is not the intention of the legislature that every criminal should be tried under the special anti-terrorism laws like UAPA, where the fallout of their activity does not extend beyond the normal frontiers of ordinary criminal activity. By introducing the offence of terrorism under the regular law, it would appear that such distinction has been done away with. One wonders why. This offence also brings within its scope economic security. Unlike the UAPA, it is not defined under the BNS. Economic security is not defined. But the High Court of Kerala, in Muhammad Shafi's case, gave a restrictive meaning to the offence of terrorism in relation to economic security under the UAPA, limiting it to the offences such as counterfeiting currency. However, without any definition under the Indian Penal Code, a wider meaning could be given to economic security. Considering the width of the phrase, any form of financial activity could, at the whim of a police officer, be categorized as financial terrorism and could be included within economic security. This could include recent incidents like the Hindenburg shorting of shares on the Indian Stock Exchange, which caused the stock exchange to drop by a significant number of points and in a week lost about $100 billion in market value. It could include cases like the attack of George Soros on the Asian and UK currencies in the mid-90s, which was known as the Asian flu, or a silver shot by the Hunt brothers in 1980. It would include the Bofors scam, the Augusta Westland scam, the Harshad Mehta scam, the ILFS scandal, may also be considered as threats to the economic security of the country and could be included under this offence of terrorism. However, if we want to protect foreign investments, and I say this to my learned friend here, if we want to protect foreign investments and be an open economy, a restricted meaning ought to be given to economic security under this offence to avoid the misuse and abuse of this provision. Although the offence of terrorism under UAPA is a scheduled offence under the NIA Act and is investigated by the NIA, investigation of the same offence under the BNS can be conducted by a state or local police. Another new offence created by the BNS is the offence of organized crime. Section 111 and 112 introduce organized crime as an offence under this central law. Organized crime is penalized in some states through state legislation like the Maharashtra Control of Organized Crime Act. The definition of organized crime is identical to the definition in the MCOC. Like offences under state legislation, it includes a continuing unlawful activity carried out by groups of individuals acting in concert, either singly or jointly, or as a member of or on behalf of an organized crime syndicate by the use of violence, threat of violence, intimidation, coercion, corruption, or other unlawful means. Filing more than one charge sheet in respect of an activity within a period of 10 years against a group of persons and where the court has taken cognizance would make such individuals part of the continuing unlawful activity group. The BNS now specifically includes economic offences within the definition of organized crime. Economic offences have been defined in the section to include criminal breach of trust, forgery, counterfeiting of currency notes, bank notes and government stamps, hawala transactions, mass marketing fraud, or running any scheme to defraud several persons, or doing any act in any manner with a view to defraud any bank or financial institution or any other institution or organization for obtaining monetary benefits in any form. This has serious implications again at the level of protecting business and a thriving and growing economy. If a group of individuals are charged with cheating a bank and multiple charge sheets are filed, it is likely that such person could be charged under the organized crime offence. Take the example of consortium lending by a consortium of banks. If there is a default by the borrower of a consortium loan and each member of the consortium files a case for which separate charge sheets are filed, this may be an unlawful continuing activity and could come within the scope of organized crime. Other examples are cases of Ponzi schemes like chit funds, plantation schemes, home buyer frauds, and multi-level marketing schemes. The makoka itself has been used as a weapon on occasions to settle commercial disputes with persons filing false complaints of extortion in property disputes under the MACOCA. The Supreme Court has held that MACOCA could be applicable even in the context of the Essential Commodities Act, but added one additional caveat. To apply the provisions of MACOCA, something more in the nature of coercive acts and violence is required to be spelt out so as to bring the unlawful activity complained of within the definition of an organized crime. So the element of violence was there. But would this observation be relevant with the inclusion of the above explanation that includes economic offences where there is no violence and there is only a fiscal or a monetary implication? Another issue is whether the passing of these laws would be treated as a deemed repeal of the earlier legislations of the MCOC or the UAPA. The Supreme Court in the case of Bharatiya upheld the MCOC, saying that the state's legislature's power to enact the law was based on entries related to both the state and the concurrent list. The MCOC was enacted on the basis that the power of the state to enact the law was based on entries relatable both to the state and the concurrent. So, how will we now deal with this particular issue where the definitions are identical in both the legislations and what is going to be given priority? It is also possible to argue that a state law being a special legislation, the same may have to be given precedence over the general law, which is the BNS. 26 of the General Clauses Act gives the state the option to decide under which law to prosecute. So then there is another offence, petty organised crime. This is a brand new offence. It is a newly introduced offence which aims at dealing with gangs or groups involved in lesser crimes. It penalizes minor offences such as theft, snatching, and similar activities undertaken by a group either individually or collectively. However, the term criminal group or gang has not been defined. The explanation to the clause lists certain types of theft, there is again a definition, which including trick theft, theft from vehicles, dwelling houses or business premises, cargo theft, pickpocketing, theft through card skimming, shoplifting, theft from ATMs. But there is no pecuniary limit set for these crimes. So how are they petty organized crime offences? If these offences are part of the petty organized crime, which is all these explanations of theft which I just told you, will they be excluded from the organized crime activity offence itself, which is under 111? So we have now a very peculiar situation where you don't know whether you're under 111 or you're under 112. But we as lawyers will certainly ask for the exclusion from the 111 if it is included in the 112. But traditionally, under the MCOC laws, all of these were all treated as part of organized crime activities. So I have not understood, again, the reason for these very fine distinctions that Parliament has sought to bring in. Then the offence of sedition has been omitted. However, the BNS now seeks to criminalize acts endangering sovereignty, unity and integrity of India, punishing them with imprisonment for life or imprisonment up to 7 years. At first glance, this appears to be an offence similar to 124A, but with a minimum punishment which is increased from 3 years to 7 years. But a closer look at this provision shows that it is essentially a recreation of the offence of unlawful activity punishable under section 13 of the UAPA. So now you brought section 13 of UAPA into the general law as if it's a substitution for 124A, but the definitions are identical. The offence under the UAPA is broader, dealing with cessation of a part of a territory of India or a separatist activity, unlike sedition, which dealt with disaffection towards the government. It criminalizes actions which seek to incite or excite secession, armed rebellion, subversive activities, or encourage feelings of separatist activities endangering sovereignty or unity and integrity of India in place of a mere disaffection towards the government. However, without a legal definition, terms like subversive activities remain vague, potentially criminalizing legitimate protests and dissents against government. This lack of clarity indicates a need for judicial intervention similar to what was done with the offence of sedition to avoid its misuse and to avoid its impinging on the Article 19 rights. Similar to terrorism and organized crime, the purpose of enacting a similar offence in which is already present in the statute book is again not clear. The procedural safeguards provided in UAPA and MACOCA are not available under the BNS. These safeguards, such as allowing senior police officers to investigate a terrorist act and mandatory sanctions from the state or central government before cognizance can be taken of a terrorist offence play an important role in checking the abuse of power. The state legislations provide various checks and balances for invoking the provisions of the statute, like the FIR cannot be recorded without a senior officer's sanction, investigation to be done by a senior officer, and cognizance, sanction prior to taking cognizance. But none of these safeguards find themselves in the BNS for the identical offences which have now been introduced. However, equally, and of course I think the legislature is very uniform in its approach to life, however, equally the deviation from the BNS is that the UAP and MACOCA severely restrict the rights of accused and enlarges the state's powers, particularly regarding anticipatory bail and remand periods during investigation, which are more favorable to the prosecution. Evidence collected through interception of wire, electronic or oral communication can be relied upon by prosecution under UAPA along with mandatory presumptions in evidence that are applicable to offences of terrorism. But these provisions are also absent in the Nagarik Suraksha or the BNS, and therefore we now treat all these offences like a normal criminal offence, which will be with 15 days of custody and with a maximum of 90 days, unlike all the other provisions. The twin conditions which have actually worried the country are no longer applicable to terrorist offences under the BNS. I think there's something good that came out of this. The BNS then, and let me take another section of offences. The BNS introduced a new chapter titled Offences Against Women and Children to address sexual offences. Similar offences under the IPC were part of the chapter on offences affecting the human body. The implication of such restructuring is that sexual offences are only recognized if committed against a woman, and that too only by a man. In IPC, rape is a gendered provision where the offender can only be a man and a victim a woman. This is despite the statement of objects and reasons of the BNS, mentioning that various offences have been made gender neutral. But this does not apply to the offence of rape. Only two provisions under the category of criminal force and assault against women have been made gender neutral, which is section 76, which is assault or use of criminal force to women with intent to disrobe, and section 77, which is voyeurism, which now opens with the word whoever, unlike in the IPC where it was any man. The BNS for the first time includes transgender within the definition of gender to have the same meaning as in Transgender Persons Protection of Rights Act 2019. Therefore, whenever the term he has been mentioned, the same is to be construed as including transgender persons as well. However, curiously, transgender individuals have been excluded from the purview of the definition of woman or man, and hence a sexual assault by or against a transgender is not recognized as rape. Another aspect of the new act is that it completely misses out on the assault and rape between persons of the same sex. Earlier, such offences were brought within the purview of section 377. The consensual sex amongst persons of the same sex, which was also criminalized under the section, was decriminalized in Navtej Johar's case recently. The Supreme Court was careful at the time of the judgment and held any act of the description covered under section 377 IPC done between two individuals without the consent of any one of them would invite penal liability under section 377 of the IPC. Similarly, so please mark it, any act done between two individuals without the consent would be covered under 377, which is effectively rape. Similarly, the Supreme Court held, however, if any one, by which we mean both a man and a woman, engages in any kind of sexual activity with an animal, the said aspect of section 377 is constitutional and it shall remain a penal offence under section 377. The BNS, however, misses both and excludes sexual offences between persons of the same sex and also excludes bestiality because 377 is one of the omitted sections under the Act. Another significant change is that the age of consent for a married woman under the definition of rape is increased from 15 to 18. This change seeks to implement the Supreme Court's judgment in independent thought, where the Supreme Court struck down the exception 2 to section 376, which provided immunity to a husband if he had sex with a wife who was above 15 years of age as discriminatory and violative of Article 14. However, the Supreme Court refrained from making any comments on marital rape. There was a need to consider the marital rape exception, which the legislatures have chosen not to address. The legislatures also missed addressing the archaic provision under section 98 explanation 2, which permits sexual intercourse with a minor wife. While dealing with punishments, all these offences provide for a minimum of 10 years. Considering societal evolution, there is a need to vest discretion in the sessions judge to impose punishments lower than the statutory minimum when circumstances warrant it, especially in cases involving sexual offences. The BNS criminalizes sexual intercourse based on deceitful means, such as a false promise of employment or marriage. Sexual intercourse based on a false promise to marry, which was previously considered rape, has now been categorized as a separate offence under section 69. Sexual intercourse by employing deceitful means, it penalizes sexual intercourse based on deceitful means, which includes the inducement for or false promise to of employment or promotion or marrying by suppressing identity on a promise to marry a woman without having intention. The Act also does not penalize sexual assault committed on a transgender. So what you all will see here is the earlier principle for introducing this whole element of false promise to marry within the domain of rape was the question of the absence of consent is how the Supreme Court interpreted it. So when you look at this provision of rape today, it's all about absence of consent. But since there's an inducement, they've now treated this as a separate category of an offence because there's an implied consent by means of an inducement. So they've just categorized it as a new offence. So in recent years, we have embarked on a transformative journey in our legal landscape, prominently featuring the decriminalization of various offences through legislative means such as the Companies Act and the Jan Vishwas Act. By aligning our legal framework with contemporary societal needs, we ought to have embraced a more progressive, pragmatic, and humane approach reflecting a nuanced understanding of justice and social change. However, the BNS failed to make use of the opportunity to decriminalize many offences. There's one major, and if I may just say in conclusion, there's one major and serious lapse in my view. There are no provisions dealing with offences relating to the internet. The Information Technology Act is limited in its creation and application to offences. However, given this opportunity, the BNS should have included a Bharatiya Abhashi Digital Dand Sanhita. In conclusion, if I might say, that the penal code introduced by Lord Macaulay in the 19th century has undeniably stood the test of time, emerging as one of the longest surviving codes in the common law world. Despite the passage of decades and numerous societal shifts, many of the offences outlined in the original code remain relevant today, a testament to its enduring wisdom and foresight. The fact that substantial overhauling of the penal code has never been deemed necessary speaks volumes about its efficacy and adaptability to changing circumstances. Its resilience in the face of changing times is a tribute to the meticulous craftsmanship of its architects and the enduring relevance of its principles. And therefore, if I may only say, because let me tell you that there's a lot in the BNS which can't be covered in this very limited time, I just thought I should share some of my views about some of the inadequacies, if I may call them, of the BNS, where there was an opportunity after 75 years of law being developed to introduce within the BNS provisions which take care of the principles that have been evolved by the Supreme Court over the last 75 years. But I'm sure that as all of us here will see this as a great opportunity as young lawyers to now keep interpreting this entire law which will keep us going for the next 100 years, and there'll be enough chaos and confusion, if I'm sorry to say, when there was an opportunity, in the words of Lord Macaulay, to say that there should have been certainty in the area of criminal law. Thank you very much, and I think the Bar Association has a lot more to do with various other provisions of the BNS, because I've just touched the tip of the iceberg, and I'm sure that this will continue. Thank you very much.
Thank you so much, Mr. Amit Desai. You have, I think, the person who needs to look at it is Sujit on my right. After, after you have said you've not covered anything, and yet you have, I think the questions that you have raised, I do agree with you on that part, that once you get an opportunity to overhaul an existing regime of law, then you must look at it carefully to see that you don't omit anything and you don't add anything. And if you start incorporating another statute into this statute, then the interpretation becomes worse. Because both acts have a different meaning altogether. And then you have talked about a state, what happens to union territory? It has no jurisdiction. So how does it do it? So all these questions will arise, but it's good for us in one way, but bad for otherwise also, because the system which was in place for all these years, if we want to change it, then to my mind we should change it, overhaul it in such a way that it serves the society. Ultimately we are looking at what? We are looking at fairness, we are looking at something, people are not misusing it, but the number of things that you have, points that you have raised, I'm sure one session, I don't think in 5 full 3-4 days, Sujit will have to reply to all this.
I have diligently taken notes.
And this is only a beginning, as he said already. Without taking your time, let me now turn to my left and request Siddharth Dave, if he has to add something for Sujit, I don't know, but maybe he has to subtract something. Let's see.
Thank you, Mr. Chandiyo. It's a difficult task to follow Mr. Desai after his extensive speech, which covers almost everything that one has to say of any significance under the BNS. And I also noticed during his entire speech, he didn't refer to the full form of the new act. He conveniently chose to refer to it as BNS. And I was sitting there and wondering whether it's one of the two reasons. That mentally he wants to replace IPC with BNS, or the other one, that maybe sometimes he'll falter in pronouncing this. So following his act, I'll also stick to saying it as BNS. So I don't think there was any requirement for bringing a new code of the IPC. There just was not. And that is proved by the fact that the BNS just reduces the number of sections, and it reduces them in a manner that if you have a look, that suppose under a particular offense, like robbery, there were various sections dealing with robbery. They've all been consolidated, those sections have been consolidated and put under one section as the subsections. The sections remain the same from IPC, but they now become subsections. Likewise, you have under for dacoity, and they have compressed the sections so as to reduce the number of sections. The definitions by and large remain the same also. So substantively, if you were to ask me, is there any difference between, aside from the sections that Mr. Desai mentioned about the new provisions for organized crime, petty organized crime and terrorist act, are there any substantive differences between the IPC and BNS? One would just have to answer and say, no, there isn't. What is even stranger is that, and shows a slight, I don't mean to be disrespectful in the manner that it has been done, what is even stranger is that the illustrations from 1860 have been retained in the illustrations that we are giving to the definition of offense in 2023. So if you have section 300 of the old IPC, which is murder, definition for murder, which is now section 100, and you have fourthly, which is an act which is so eminently dangerous, And in that you have an illustration that A fires a cannon into a crowd. That definition is retained under BNS. A fires a cannon into the crowd. Now there are no cannons, firstly. I don't think anyone has a cannon in their possession. You may have fired, except for military areas or naval areas or where they have to, for gun salute, maybe that. But there are no cannon available for somebody to go, there is a crowd, yes, let me fire this cannon into a crowd. No. You could have possibly applied the mind, whoever was suggesting these changes, could have applied their minds and said that whoever takes a light machine gun or a machine gun and fires it into a crowd, weapons that are more ordinarily available now in 2023 than what was ordinarily available in 1860. That is one such illustration that I just want to give. Or A shoots at a fowl, that is a bird, a fowl. Now, if you shoot at a fowl, you will be prosecuted under the Wildlife Act. So there is nobody is going to shoot at a fowl, which will be mistaken that if a bullet hits somebody else. So there is the small amount of non-application of mind. If you are trying to make an act more applicable to the present time, and you were enacting it, the parliament that is, some amount of thought process ought to have gone into it to make it more relevant for the present time. That is one. The second aspect is there are various things which were prevalent in 1860, which have been retained in 2023, apart from the illustration that I gave. There is always a difference in the times in 1860 of, suppose, house trespassing at night. Night was a period in 1860 before electricity, etc. came into being, modern electricity, where there was complete darkness. So offences which were committed at night, it was difficult to prove who committed those offences, were made more stringent than offences that were committed in the daytime. The BNS retains many of those distinctions of night only to clarify that it is after sunset and before sunrise. So night is clarified by after sunset and before sunrise, but the offence remains by and large the same. For reference, it is now you have a 309(4), which is punishment for robbery between sunset and sunrise on a highway, which was earlier 392, which said that if there is robbery at night, then you have a more stringent punishment for it. Then you have accordingly for that. And one other aspect that I just want to mention in passing is, of course, this will be covered in the topic tomorrow, is that many of the sections here which continue to provide for imprisonment for life. So you have the earlier 409, the equivalent of which you have now, because I'll have to keep cross-referencing, is 316(5), which is criminal breach of trust. The punishment is for life. You are punishing somebody for criminal breach of trust. That has a history which I'll just address, and including the forgery aspect, which was 467 earlier, which is now 338. That is also punishable for life, of a valuable security, etc., for life. So in the olden days, in the British time, forgery, etc., which led to the trial of Nand Kumar for hanging, death by for forgery, you have retained, or the parliament has retained, the extreme punishment for life, which would now be equivalent to something like murder, for forgery and for criminal breach of trust. That is one aspect of it they have certainly overlooked, because the punishment should have followed the normal cheating, either 7 years, you can make it maximum 10 years, etc. But to punish for life, and mind you, I checked the CRPC, or the new BNSS, the new BNSS, I checked that it continues to be tried by magistrate of first class. So it is bizarre, because if one is having an overhaul of these sections, firstly reduce it to that which is tribal. If you want to retain it to be tribal by a magistrate's court, reduced the section because the punishment, the amount of punishment that the magistrate can give even under the new code of the BNSS is about the same as in the Code of Criminal Procedure. So these are all, this shows that yes, one wanted to overhaul the acts that existed. Fine, nobody can stop the parliament from doing so. Maybe the motive was very good, we need to have a new act. Yes, it is. But it also shows a non-application of mind, that if you are retaining the lacunas or problems that existed and have plagued from 73 or even according to the 1898 code, plagued the judicial system, then address it, but it's not been addressed. The other aspect is what Mr. Desai spoke of, is the introduction of the 3 new offences which are standing out somehow in every criminal lawyer who goes through it, is organized crime, petty organized crime, and terrorist act. Surprisingly, all the 3 have been introduced in the chapter of offences affecting human body. Now, how does organized crime, petty organized crime, and terrorist act affect the human body? Yes, it does in part, because murder is a component that may be there in continuing a terrorist act, and even in causing bodily harm as far as the organized crime is concerned, not petty organized crime. But how does it fall under the chapter of offences? Because in those chapters, the ingredients of those offences, and as was touched upon by Mr. Desai, the organized crime is a direct lift from Makoka. Makoka, Guchkoka, Makoka is applicable to Delhi because Delhi has made it applicable. It's a direct lift from Makoka. And the Terrorist Act is a direct lift from UAPA, the amendment that came in section 15 as far as UAPA is concerned. So there is nothing new about that. You are not defining it in any manner. In fact, the definition of UAPA of Terrorist Act in UAPA and now under BNS is such that somebody who causes a terrorist act abroad to which India has some friendly relation or some, can be prosecuted in India, which has no other connection except for that country where that terrorist act is being caused. So that creates some amount of a break in the link as far as the person in India either conspires or does a terrorist act abroad but will be prosecuted in India. So those are, and that was a problem, that is a problem which is there in section 15 of the Terrorist Act, where persons from India went to join ISIS to fight a country. It was not a fight that related to India, but fight in Iraq or wherever they went in the Middle East to fight, were prosecuted under UAPA in India. So one of the arguments that was taken is that, look, there has no causal connection between what I'm doing there as far as India is concerned, because I'm not causing any harm to India as its sovereignty or integrity of India is concerned. But of course, that lacuna also continues to remain. Now, apart from these 3 being part of the Terrorist Act, which of the Terrorist Act and organized crime and petty organized crime. Now, petty organized crime is a very, it's a sort of a section which has no utility in any manner, except because every person who's committing those petty offences in any case would have been prosecuted for theft or snatching or some of these offences that are being carried out. So to have a special section that would prosecute a person to show that yes, there is a petty organized crime, that petty organized crime or a gang carries out activities like snatching or theft, and therefore they are to be prosecuted under the new section, does not sort of make sense to put it as a separate section itself. Apart from that, all these 3, there is also an issue of solitary confinement, which is there as one of the punishments under the Indian Penal Code, has been retained in totality under the BNS under section 11. Now, solitary confinement, as we are proceeding towards a more, as we keep saying, a civilized manner of living or a more civilized manner of living, solitary confinement, it is known clinically and by experts, has a very deleterious effect on a human person. The period of solitary confinement remains the same under the BNS. However, the retaining solitary confinement as a punishment that the court can award, especially when we are moving towards a situation where cruel and unusual punishments would not be awarded, is a sort of a lacuna which is also ought to have been addressed by the parliament. Then there are some good things, which is like 310 and 311 of IPC has been done away with, which was thugs. Now, thugs was a sort of a term given to people of who used to catch hold of people on the highway and would commit offences against them. So, thug was a word which was not of a very good context. So, that has been deleted. So, let's not say that's all bad under BNS. Thugs have been deleted, and attempt to commit suicide under 309 also has been removed. Apart from those, there is a punishment that has been added called community service, which is a good thing. Suppose in smaller offences, if the court is of the opinion, when we argue in court that invoke the Probation of Offenders Act under 360 of the CRPC, we used to say the court can award in smaller sentences community service to a particular person, so as to the person need not have to go to jail or custody to serve out, and that's a good, more humane approach as far as addressing the offences and punishing for the offences are concerned. Now, in all of this, the problem that will be caused for the next 20 to 25 years is that, of course, we as lawyers and everyone by the time, especially in the Supreme Court or in the High Court, the problem that will, by the time it travels up there, we will have all the bare acts, etc. But imagine a situation in the talukas, imagine the situation at the district level, imagine in the situation in remote levels, imagine the police. Now, by criminal lawyers, because it's not, they generally master just a manual. They just have three, CRPC, IPC and Evidence Act, and they don't need any other books. They just carry this everywhere, wherever they go. And by period of time, you remember the sections. Unlike civil law, which is much wider, it's about 70% of our lives are governed by civil law and 30% by criminal law. The sections that are going to be imposed are going to be completely different. So we are relying upon the registration of the FIR under the new sections, under BNS, and I'm told that it's from 1st July it's going to happen. So the police officer should be well aware in a remote area about the new sections, because he can't go back to the IPC, which is the ordinary. The lawyer arguing for the first time before a magistrate on a remand or for bail has to be aware of the new provisions under the Act. When it travels up to the sessions, likewise is the situation. Travels up to the High Court, likewise is the situation. And by the time it comes up to the Supreme Court, as Mr. Chandiok said, it's good for some of the lawyers, or some of us, for the lawyers, because we just have to get up and say, this section has not been interpreted because it's a new section and it requires interpretation. And so the court should address it and start interpreting. So it's a valuable waste of time, according to me. The third thing about the problem with this is, it seems to have been, and this is my reading of BNS, is the reason why they have relocated the section. I would have not had much of a problem. You can call it BNS and you can keep the sections as they stood, because everyone knows 302, everyone knew 376, everyone knew 420. I mean, 420 became a sort of a mimicry even in court. Kya tum 420 so sort of a thing it got for cheating. Everyone knew those sections by then. It didn't require going to a book and referring it to them, and kept the sections as it is. But what seems to be the flow, and if you go through the index, as I went through the index, the emphasis of the parliament is that we will address first the protection of women and children. That, according to the parliament, seems to be of primary importance. Therefore, that falls as the first offences, apart from abetment, etc., and general exception chapter that is there. Not offences against state, which was there in the IPC. Thereafter is offences affecting human body. So women and children and human body have been given priority over other sections, which were offences against public tranquility, offences of against state, offences, obscenity, etc., which were there, which preceded up till section 299, which preceded the in the IPC. and from there it goes down and goes to the least of the provision. Intimidation, insult and annoyance continues to be the last there, but in that manner it has given precedence to offences affecting human body, and last to the monetary etc aspect of it, which is cheating and forgery etc, which continue to remain at the back of this. So yes, it's a noble thought to address that the human body offences against human body should come first, but it's also causing a lot of problems in the minds of the people who have to work this act, the new act. Not only the lawyers, who of course will ready themselves, but the police, the judges of course, and various other stakeholders who are there. Now, apart from, very briefly, from touching these other aspects, what I said is the merged sections also in their own create a particular problem as far as the cross-referencing is concerned, because when you look at the books, which will have, and we used to have this earlier also, now it had stopped, that when the new 1973 code came, it had provided every BAI Act of the CRP, every BAI Act used to have a cross-referencing section right at the beginning itself. Now, having a merging section just because it deals with one offence of one kind does not necessarily make it very convenient to everyone, because you have to then go on reading the new section and finding in that subsection what was as a proper section in the IPC. I'm only pointing out in a manner of the working and the problems of this BNS that are going to occur from 1st of July of 2024. So we all will have a lot of work to do as far as working this is concerned, because you have to then search by not only by looking at the cross reference, you are not going to be able to make out whether that particular section is there in so many words or not, because you will get, suppose robbery, you will get only robbery as the sections in the BNS, but some other ingredient of which was a separate section under IPC, you will only get it as a subsection. So that also involves a lot of work. Now, apart from all these problems that are there, it does, in my opinion, does not in any manner or immensely or greatly simplify the definitions. We have been since 1860 dealing with, and the courts and replete number of judgments of Supreme Court, forget the High Courts, of the distinction between culpable homicide and murder. Now, that is one area where we have been dealing, and every argument, not every, unless it's open, like 3 dead and 4 injured in broad daylight incident, which is murder itself. But those slim distinctions that we had, I would have expected the Parliament and the stakeholders before the Parliament, the persons who advised on this BNS, to have worked out a better distinction between the two offences, because if we were to compare 299 with 300, almost all the ingredients are the same except for the knowledge part, which falls under 299. It is not there in 300, and that takes you to culpable homicide. So it would have been better if more clarity had been accorded to sections which are there in use for every day, because murders are committed every day, and murders will continue to be committed every day till humanity exists, unless we reach some sort of a utopian existence. It will continue. So clarity there. Punishment is also there. Now, attempt to commit culpable homicide, because there is a view amongst the jurists that culpable homicide by itself is not an offence. It does not, you can't be prosecuted by it. There is a view amongst, and sometimes judges also react when you are arguing to, no, culpable homicide is not, it's murder, and only the exception, then you fall under 304. But there is an attempt to commit culpable homicide, which is there in 308 earlier, has been retained as it is in the new code. So a lot of this, and forgery and false documents, complicated sections. They are complicated sections and have been retained as it is in the new, in the BNS. So according to me, the BNS still requires a certain amount of work still, even though it's just been brought in. But like all legislations in India, and Mr. Chandiok would vouch for it, like the Arbitration Act 1996 has undergone more amendments. I've never seen a slimmer act with more amendments than the Indian Arbitration Act, because it just goes on amending. So maybe the parliament, and as the problems arise and the interpretations arise in BNS, maybe the parliament will be aware of the amendments to make in the manner that has been suggested. But above everything else, I would have been happier, and I'm sure a lot of you would agree, had the sections just remained to be numbered as they were numbered, and then made the changes by addition, Terrorist Act or whatever acts that are there. I'm not commenting or going deeply into the Terrorist Act or Organized Crime Act or organized offences, which is now separately made an offence because Mr. Desai touched it. And but yes, it is. They are very wide. They are open to a lot of misuse by the police authorities in the states, because they are so wide in their interpretation that any and every activity can be brought under the Terrorist Act or Organized Crime Act. And it is only on the ipsi dixit of an investigating officer who, if he has a grudge, or as we all know on the criminal side, who has a grudge against a particular person, can simply invoke this section, and you are in for a long time, because securing bail, now jail and not bail is being the rule. Securing bail or getting out or proving your innocence is a tall ask in these days. So keeping such wide definitions, which are already causing problems in the... Then the other part, just before I leave to the other speakers, the other part is, what about, can it be punishable under two offences? Somebody invokes in Maharashtra, you have Makoka, invokes Makoka as far as, and also the Organized Terrorist Act under this section 113 of the IPC. Both have been invoked against a particular person. Of course, one will rely upon the general clauses that if it's an act under two sections, you can be tried under both, but you will be tried under both the sections. I'm just pointing out the enormity of what will happen. So there is the Makoka, UAPA section 15 and section 13 of the 113 of the BNS for a terrorist act for a person to be tried. So my endeavor was not to, because it's not possible to go into the definitions, and this is not a class or a lecture or anything in that sort. It's only to point out the pitfalls and the problems that are going to arise in the working. And these, according to me, are some of the problems. Many of the problems we will all discover when we are addressing the courts in our matters that we are addressing as lawyers, in the interpretation that will crop up. And yes, it will cause for the next 20-25 years at least, till the last of the cases under the IPC is resolved or dealt with by the Supreme Court, that we start only with the BNS. So I'm really grateful to the Bar Association for this opportunity to address all of you distinguished people, and thank you for your time.
Thank you, Siddharth, for pointing out. I don't know whether it's appropriate to mention it even. I thought probably Sujit can help us there also. I remember legislation we went to Singapore, and the Chief Justice Menon was in Delhi, and actually in Habitat Center only, I remember. A question was put that, how do you make legislation in Singapore? And he said, we always have the parliamentarian with one honorable judge, whom I nominate, and two lawyers who are actually practicing on that side. They constitute the committee to make the legislation. And I thought time has come when we should do that in India also. That will also give us more employment as lawyers. Nothing else. Thanks so much, Siddharth. I think before we bring Sujit on the scene, it's time that you have a cup of tea and come back, reunite. 15 minutes, we'll be back to. Thank you. May we request everybody to be back, please. My friends who are outside, please bring your cup of tea inside only. There's no problem. There's no prohibition. Thank you everybody to be back. I think both my friends. Oh, where is this gone? Is Amit Desai has also been taken away. No, he has gone. But I thought his nameplate chala gaya. So I thought I had Amit. No, that's right. But you see, they have wanted to bring a gap between me and Sujit Kumar before he starts. So after having heard Amit and Siddharth, I think it's time for us to request Honorable Mr. Sujit Kumar to please deal with this question. I'm sure he has answers to everything.
Good afternoon, everyone. Thank you, Dr. Chandyok, for giving this much needed break. I personally needed this cup of tea. So, and now I feel so guilty to be an MP. And, particularly because I was also part of the Parliamentary Committee on Home Affairs, to which these three bills were referred to. So, but thank you, Mr. Dave and Mr. Desai, of course. He has left. So for those very, very insightful comments, it was truly enlightening. Mr. Desai, of course, was invited by the committee to give his suggestions. There was elaborate discussions for about 3 months. So the original 3 bills were introduced in the Parliament in the month of August 2023, and then referred to the standing committee, of which I was a member and has been referred to. And the mandate of the committee was to give its inputs within 3 months, and we stuck to the mandate. So on 10th of November 2023, we submitted our report to the Parliament, and the bills were reintroduced in the month of December 2023 during the monsoon session, and was passed by the Parliament. Not a happy situation. The entire opposition was expelled. So, being a member of Biju Janata Dal, it's often a tricky situation because you do not know who to sympathize with. And so this is a disclaimer, because everything that I say are my personal views and not necessarily the views of my party or of the committee that I was a part of. And I would rather agree to most of what Mr. Dave and Mr. Desai said, but since we are a democracy, oftentimes smaller parties and I spoke on behalf of my party on the floor of the House when these bills were being discussed, or rather the bills were being passed without discussions. So I spoke, and you can it's there in the public domain, and you can find out for yourself that I have agreed to most of the things that were pointed out by 2 gentlemen who spoke before me. So let me express my gratitude to Bar Association of India, Prasad, and others for inviting me to be part of this Rule of Law Convention. And I would like to particularly commend the BAI for dedicating this year's theme to these 3 new acts, because the impact is going to be monumental, not only for lawyers and citizens, not only for lawyers, but also for IOs, investigating agencies, for judiciary, but most importantly for the common citizen of this country. I mean, much has been said about how 320, 302, 420, 376 were part of the popular culture, popular folklore. In fact, there are many Bollywood movies, the Sri 420, many Bollywood dialogues that refer to the sections of IPC and was easily understood across the country. So now it will be very, very difficult. At least the first couple of years will be extremely difficult for everyone, particularly for the common litigant and citizen of this country. Uh, if you go for a simple textual comparison, there is hardly any difference between the IPC and the BNS. By and large, most of the provisions are the same, verbatim. And I will point out some of the differences where I have concerns and some of the provisions where I think good sense has prevailed. To start with, Mr. Chandiya wanted to know why the Parliament, what was the parliamentary intent to bring these three legislations. I'll tell you, I mean, of course, the statement of objects and reasons, we have all gone through and we broadly know what was the parliamentary intent. But beyond the statement of objects and reasons, when we were deliberating this in the committee and otherwise when we were being briefed by experts, including former Supreme Court judges and High Court judges, many vice chancellors, many retired director generals of police, and so on and so forth, and of course eminent lawyers. The idea was that this will bring in ease of justice. And I think it was Mr. Desai who spoke of the Jan Vishwas bill. I'm not sure, pardon me, Mr. Davi, if it was you. The Jan Vishwas bill was passed by the parliament in the monsoon session of 2023, which decriminalized a large portions of offences. So there are many offences which were in the statute book, which were really silly. So to give an example, if a labor contractor forgot to whitewash the washroom, which was being used by the workers every 6 months, then the contractor could be prosecuted. This was in the statute book. So there are many such, there were many such provisions which were done away with, thankfully, through the Jan Vishwas bill. And this was a continuity. This was a continuation of making life easier for the citizen of this country. So ease of living and ease of justice were two broad concepts which dictated the government of the day, meaning the present government, to bring in these bills. Yes, it is true that the language and the structure of IPC had become archaic, had become outdated. Mr. Dave spoke about canon. There are many such illustrations. Chariot. There are many references to the British Crown, Her Majesty. So it was certainly necessary to remove some of those languages. It was necessary to be in tune with the massive transformation that the society has witnessed because of technology, because of globalization, or because of change in societal values, attitudes. What was acceptable in 1860 may not be acceptable today, or what was probably not acceptable in the 19th century has become by and large acceptable today. Homosexuality, for instance. So it was necessary to give shape to this evolution of society, technology, etc. And over the years, many specific laws had come into our statute books through NDPS Act or Juvenile Justice Act or the Motor Vehicle Acts. So you had a generic law, and then you had the specific acts, and it was sometimes overlapping, sometimes conflicting. So it was necessary to also to bring in more clarity, and that was one of the key reasons why the IPC, CRPC, and the Evidence Act had to be overhauled. And if you go to the speech of Honorable HM, Home Minister, say Amit Shah, when he was justifying why these acts were being brought in, he mentioned about the fact that the three colonial laws were by the Britishers, of the Britishers, and for the Britishers to perpetuate their continuity, their hegemony in India. And BNS, BNSS, and the Bharatiya Sakshya Adhiniyam are by the people of India, for the people of India, and of the people of India through the parliament, which, as you all know, represents the will of we the people. So, be that as it may, these were some of the reasons. Of course, it's not comprehensive, it's not exhaustive, there are other reasons. But these are some of the reasons that were cited either in the committee deliberations or in the parliament, on the floor of the house, by the lawmakers to bring in these laws. I don't necessarily subscribe to all of this, but certainly I do subscribe to some of this thinking. One key objective seemed to do away with the colonial hangover. Yeah, this is a favorite pastime of this government to eliminate anything and everything that has some colonial connotation. So the Indian Penal Code, of course, was more punitive. The title itself had penal. So the Bharatiya Nyaya Sanhita. So the objective was that the law should be more rehabilitative rather than punitive. Hence the word justice, Nyaya, Bharatiya Nyaya Sanhita. And also in CRPC, it's not criminal procedure code anymore. And this was also pointed out by learned Attorney General this morning when he said that the new law is to be called or has been called Bharatiya Nagarik Suraksha. So giving security and that comfort to citizens of this country. Now, there are many positives. Let me start with the positives because I don't want to add to the gloominess of this room. So let me say that there are enough number of positive elements in the three bills. And since we are talking only about BNS, I'll stick to BNS. First and foremost, this idea of having community service as one of the punishments for petty offences. Right? And Mr. Dave spoke about it. I think that's a very, very progressive development. I think that will A, build trust in our citizens, and B, declutter our prisons. So today, you know, overcrowding of prisons is a reality. So I think that will certainly help with these objectives. 309, section 309, attempt to commit suicide. You know, a person commits suicide or attempts to commit suicide when she or he has lost every hope in life and needs our support, our counseling. And when she or he fails in that attempt, you punish that lady or gentleman. How cruel can one be? So I think that is probably, in my view, that is the single most welcome element that section 309 IPC has been done away with. 377, 497 adultery. I mean, of course, we can have our own arguments and debates whether 497 morality and its impact on society, should it be there. Most of the committee members were of the view, Mr. Chandiok, that 497 should be there in BNS as well. But I must really compliment and thank the government of the day that both 377 and 497, even in fact 377 as well, most of the members were of the view that 377 and 497 should be there in the new bill. But sincere compliments to the government that this were done with. 3010, of course, 3010 and 11 have been mentioned by Mr. Dave, the definition of thug and punishment for thuggery. One welcome provision is that the BNS has streamlined, the offences and penalties. So previously in the IPC, there were separate sections for the offences and for the associated punishments. So now in the BNS, you have the offences and the associated punishments in the same section itself, which I think has simplified the format. I mean, of course, we might have different view, but I think that is a welcome change. Section 111, organized crime, petty organized crime 112, 113 terrorist acts. Enough has been said about these three sections. But I think given the challenges of present day India, I think there was need for separate sections to tackle with terrorist activities, to tackle with crimes such as money laundering, smuggling. Of course, we have specific legislations for many of this, but I think there was need for enacting, for having provisions for these offences in the generic statute as well. So I welcome having organized crime or petty organized crime or terrorist acts in the BNS. Transgender has now been recognized. very, very welcome move. Section 2, subsection 10 defines transgender. The definition has been taken from the Transgender Act of 2019. The BNS does not define transgender, but I think we have given the due respect to the transgenders by having them as a third gender, a separate gender. Now, let me come to the challenges and concerns. First and foremost is this article. It is so prophetic that this morning, Justice Amanullah apprehended that these 3 bills might be challenged and the Supreme Court might be asked to adjudicate. And I see that happening. The title of the Act itself might be challenged because it's foul of Article 348, 1 of the Constitution. And for the convenience of the audience, I have highlighted it in red. The title is Section 1 of the BNS. And there were members from DMK, there were members from TMC, and I'm from Biju Janata Dal, I'm from Odisha. So Hindi is not my first language. So we vehemently opposed having the titles. I mean, I have nothing against having the titles as they are, Bharatiya Nyaya Sanhita or BNSS or Sakshya Adhiniyam. But A, it might be unconstitutional, and B, I think, imagine a lawyer in remote Tirunelveli or Kalburgi or somewhere in Karnataka or you know, it might be really hard for them to pronounce these names. So, I mean, why complicate matters when you could have just had simple English names, you know. If the idea was to remove penal, the word penal or the word criminal, then you could have thought of some different words. But I think these Hindi titles, I think, is unfair for a country which is as diverse as ours, and particularly when there is so much of sensitivity with regards to language, particularly in states like Tamil Nadu or Kerala or Karnataka. So why fuel unnecessary controversies? So I think that's the first objection which I had, and there was mighty debate in the committee, in the parliamentary committee on this. But because we are a democracy, and then of course the majority voice counts, so this was overruled. Secondly, several offences, they overlap with specific laws. Now I've given you, sorry for the font, size of the font, but you know, I'll give you just 2 specific examples. One is the Motor Vehicle Act or the Juvenile Justice Act, and there are other, the Food Adulteration Act. There are many, you know, in many cases, you know, the BNS and the specific laws, they have different penalties, they have different procedures. So this would lead to multiple regulatory regimes. This would lead to, you know, more compliance costs. Potentially, this would lead to more confusion. So I think that clarity is lacking, which I think the new law has not addressed. The third concern which I have is with regards to what is popularly known as mob lynching. Now, the IPC did not have any specific provision to punish the offence of mob lynching or hate crime. So the punishment for mob lynching, the police would register a case under 302, you know, for murder, and we all know that we are living in an age where mob vigilantism, mob lynching is a reality. In fact, the Supreme Court itself had said in Tehsin Punewala versus Union of India that it had urged the government of India to bring in a specific law to curb the menace of mob lynching. Now, I'm glad that the BNS has done that. The BNS has recognized this and has paid heed to the direction of the Supreme Court. And there is a new offence of mob lynching, though the BNS does not use the phrase mob lynching per se, but it is there under the offence of murder. But the issue here is that the issue here is that religion has not been identified as one of the grounds. Now, in the Tehsin Punewala versus Union of India case, the Supreme Court had categorically recognized religion as one of the prominent grounds in the instances of mob lynching, which BNS has failed to do. So, BNS has employed the phrase personal belief or any other ground, any other similar ground. Now, I admit, I concede that it is possible to interpret the scope of this phrase broadly to mean religion or to bring religion within its ambit. But to me, it seems rather odd that religion has not been, specifically included in the definition or in the section. So probably this is deliberate, but I think this is a very sad omission, given the state of affairs. This has been spoken about gender. The offense of rape. Both my previous learned speakers have spoken about this. The statement of objects and reasons specifically highlights that the BNS aims to be gender neutral, and many of the provisions of BNS have in fact been made gender neutral. For instance, the offences, the provisions relating to kidnapping, procuring, hiring, or employing minors to commit offences, they have all been made gender neutral. But sadly, the offence of rape has not been made gender neutral, which is I think very, very unfortunate. We know that men are routinely raped in our hostels, in our prisons, and otherwise largely in the society. The Law Commission in its report in the year 2000, Justice Verma Commission in 2013 had highlighted this and had urged the government to make the offence of rape gender neutral. So I mean, it's not that only women are the victim always, men are also victim of rape many a times. So I'm rather disheartened that BNS does not protect men against sexual assault, particularly because now there is no 377 in the BNS. Right. So in Navtej Singh Johar versus Union of India, the Supreme Court held that the provisions of 377. Okay. So in Navtej Singh, as you all know, consensual sex between adults of the same gender was decriminalized. But the Supreme Court added that the provisions of 377 will continue to govern non-consensual acts against adults or acts of bestiality. Now, in the absence of 377 or any provision akin to 377 in the BNS, how are you going to punish bestiality or acts involving non-consensual sex? So, sexual assault against men. So, there is no provision in the BNS. So, this is, I think, quite a serious omission which needs to be relooked. There is another concern in the BNS, which is the lack of distinction in punishing attempt or abatement and completed offence. Section 111, organized crime. The offence, the BNS creates no distinction between the attempt to commit an organized crime and the attempt or abatement of the offence. Similarly, Section 104, murder committed by a life convict. Section 1092, this is BNS, 104 of BNS and 109 subsection 2 of BNS, which is attempt to commit murder by a life convict. So for both the offence and the attempt to commit that offence, the punishment is the same, which is rather arbitrary in my view. Then the other concern in the BNS is, sorry again, I keep using BNS, Mr. Dave, so it's pretty comfortable using BNS rather than the long form. Section 61 of BNS has defined criminal conspiracy, which is akin to 120A of IPC. The difference being that you have this phrase with the common object of, which wasn't there in the 120A IPC. Now we all know that criminal conspiracy and common object are different concepts. Now, common object has been used to denote meeting of minds or shared objectives in committing an offense, which is not necessarily what criminal conspiracy is. So now we don't know what the intention of the parliament was in adding this phrase, with the common object of, while defining criminal conspiracy, and this will potentially lead to confusion. Section 113 has been comprehensively addressed by both my predecessors. This is similar to section 15 of UAPA. Now, the concern here, again, this has been pointed out before. An explanation is added to the section, which allows an officer not below the rank of an SP to decide whether to prosecute a terrorist activity or an act under UAPA or BNS. But what is the basis of making that decision? On what basis will the Superintendent of Police decide whether to prosecute under BNS or UAPA? That clarity is lacking. So this is bound to cause confusion. So again, this should be relooked. Organized crime, lot has been said about it. Here the concept of economic offences has been brought in for the first time, which I think is a welcome move. But it is unclear whether the provision also covers foreign entities or organizations, criminal organizations operating outside the territory of India, but committing crime in India. Whether they will be covered, this is unclear. So we don't have that clarity. Now another personal concern of mine is with regards to the definition of petty organized crime. Now, selling of public examination paper, I would like to see a show of hands. Is this a petty crime? I mean, can you club it with snatching? Can you club it with theft? This is what precisely has been done. I mean, it's a huge racket. It's a huge syndicate. We are playing with the lives and career of our youth, of our children. And you put it, and in fact, I was so vehement in my opposition to have this in the section 1112, and club it with other so-called petty offences such as snatching and theft. But of course, it still continues there. So I think at some point this should be looked into. Just two more points and then I'll conclude. Section 226. As I said before, probably the single biggest or the single best outcome of the repeal of IPC was 309, repeal of section 309, attempt to commit suicide. But a new section has been inserted, section 226, attempt to commit suicide to compel or restrain exercise of lawful power. Now, I can sit on hunger strike. So will I come under the ambit of 226? Because sitting on hunger strike for a couple of days might cause a death, right? So we see that is a democratic process. It's an expression of our democratic right to sit on strikes and also on hunger strike. So does it now going to cause an offense under 226? We don't know. So I'll stop with that. I'll be happy to take if there are any queries, but I think there are a lot of good provisions in IPC, CRPC, in the Evidence Act. For instance, the concept of zero FIR, concept of e-FIR have been introduced. So now imagine this is such a great service, particularly for women, for rural women, because they had to go to the police station to register their FIR, and you know how things go in our police stations and how they are dealt with. So now the concept of e-FIR and zero FIR, I think that will reduce the burden on citizens, particularly on the women folk. I wish there was some provision related to multiple FIRs. Without naming anyone, you know that in the past we have seen multiple FIRs were lodged against a particular individual, cutting across party line, for the same offence. One in Kerala, one in Calcutta, one in Delhi, one in Nagpur. So Supreme Court had to step in to club all these FIRs. So I guess the lawmakers should have taken care of this, and I think something should have been introduced in the bill, in the 3 bills. So hit and run cases, as you probably know, that has been put on hold because of the opposition from the All India Motor Transport Congress. Now this has been made more stringent. But the idea was that the concept of golden hour, which is a term which has been introduced in the Motor Vehicle Act as well. That's the most important time when a person's life can be saved. So if a motor vehicle hits a victim and flees from the scene of the crime and does not report it to the nearest police station or the magistrate within a reasonable time, then that offence has been made more stringent. So I think the opposition of the All India Motor Transport Congress is not justified. I think after the elections, the government will probably will lift the hold which it has put on Section 106, subsection 2, which is popularly known as hit and run. But I think that's I don't think that's a harsh provision, because it is our civic duty. We all of us can have accidents and can ourselves indulge in accidents or cause accidents, but it is our civic duty to do the next best thing once an accident happens. So I'll stop with that, Mr. Chandio, and
thank you so much, sir. Thank you very much for that illuminating address.
Mr. Chandio, if you give me 1 minute, Mr. Desai, I think in lighter vein, spoke about having a separate digital. Yeah, actually, I think he was not. I think he was serious about it. The Parliament is contemplating bringing something to be called the Digital India Act 2024 or something. I hope it's not called the Bharatiya Internet Nyaya Sanhita or something. So yeah. Thank you.
Thank you. Though you have been able to say many things on the good side and the bad side of the enactment, before I put everybody to open the house for questions, because my friend has to go before I request my friend to speak and make their concluding remarks. So let me ask if anybody in the audience would like to put a question to you. I have a question. Yes.
Is community service defined anywhere in the Act? What exactly constitutes community service? No. So it's left to the discretion of the court. Is that?
That's correct. Community service has not been defined. So again, that's a grey area.
Also, with respect to community service, I think the cases of snatching of old people are very much in rise. We saw quite dangerous old people walking in sense of snatching. And community service, it's not deterrent at all. Like, people will say, okay, I snatch and I do some community service. I don't know what community service is really. So it's not, it may not be deterrent at all.
But that is one of the options available to the magistrate. So it's a judicial discussion. Depending on the gravity of the offence, the magistrate.
Because such instances are mostly happening with elderly people. So
Yeah, but community service is one of the options of punishment available
Yes,
to the
true.
right. So it's not necessarily the only option available. So
Yes, please. Can
Sir, since you are a parliamentarian also and a lawyer, of course, so my query is not pertaining to BNS, but some other. Since you are a parliamentarian and you were in the committee also, there are many more acts also, old British colonial acts also. So was there any discussion on those, changing those, replacing those laws also? Because advocate community, legal fraternity, equally interested to know these things also. So your views, sir.
yeah,
Thank
we mentioned the Jan Vishwas bill. Sorry, the Jan Vishwas Act now. So the Jan Vishwas Act actually has repealed many of the obsolete and archaic and outdated laws which were there in our statute books. 182 odd, acts have been repealed. So from 42 different ministries, pertaining to 42 different ministries. So I think this government is one has to really compliment this government that they are very serious about repealing these archaic laws in tune with the manifesto promise they made: minimum government, maximum governance. So this is something which really one has to give to this government.
Good afternoon, sir. My question is also for Sujit, sir. Sir, I had this query. This is a young lawyer from your state of Odisha. So I had a query that the Nyaya, which the Act talks about from the very first perspective, stands for the victim, but the entire criminal justice system, the so-called criminal justice system, is always accused oriented, which talks about the rights of the accused, revolves around the accused, and there's a very less ambit left in all the criminal justice system for the victim, who is actually the victim and for whom the entire state fights for. So, but still, that is a gray area which is not added. The physical and mental well-being, both way around, of the victim is nowhere addressed in any criminal codes throughout. Neither it was there in that time, and nor after so many years that is not inculcated, which is a very important dimension now. So what is your take on that? Or any of the panelists can answer it.
It's raining lots from Odisha. So I think that's a very pertinent point. Tomorrow you will I guess you will hear more about it when BNSS is discussed. But there are some welcome provisions with regards to victim protection and compensation in the BNSS. So
victim compensation was there.
It was there earlier.
That was there. But apart from that, rehabilitation centers are also there only for the rape victims. So what about the other victims, especially when it comes to digital media, social media, bullying, cyber bullying, and cyber pornography? And I also had my dissertation on this. Like cyber pornography, all these heinous crimes which does not impact you physically more, it impacts you mentally more, it destroys you completely, and especially the younger generation go into depression and everything. So that means that's the new challenge which our society faces every now and then, I guess in all of the states. So I think that is something which actually needs to be addressed.
I completely endorse what you have said.
But yes, sir, that is my thing which actually needed to be inculcated in it.
No, I completely endorse your views, but at the end of the day, it's a function of resources, it's a function of, our capacity. So,
see, two things, like in the petty organized crime section, there was just an enumeration of examination papers. Now, there have been several enumerations in earlier act, which, as Mr. Desai said, were quite well thought out. Now, we have a feeling that such enumerations here have been randomly put in, whether they are exhaustive, whether they are just representative. None of this guidance seems to be available within the code. So that is one area. So whether there was discussion on how these, in the committee's evaluation, how is this enumeration of various offences and other things, the examples, how well thought out it is, and whether to put a further explanation on these things. Second, July 1 is the date of implementation. And these laws are to be implemented through the hands of the police officer. So, if it is to be given in their hand, was there any discussion at all in reforming and educating the police? Whether preparing them before you roll out these, where there is so much confusion for us lawyers to understand, and it will take time for the law to reach to be clarified by the Supreme Court. But what about the danda of the policeman? It will fall instantly on the citizen. So, what is being done to soften that blow or its ferocity? So, July 1, how does it come and whether there are these steps contemplated, especially when the committee was under Ministry of Home, which looks at all this.
July 1st.
Yes, July 1st.
2025. That's a suggestion. That will be all right. That's
Yes.
1 year.
So as a lawyer and as a member of parliament, since you come from Rajya Sabha, your tenure runs, I think this is one of the biggest concerns which we will request from here as a house resolution to you, apart from nitty-gritties, that its rollout has to be much more citizen friendly. Right now, you are saying it's a Nyaya Sanhita, but what you are doing is giving a baton push. So that's what I wanted to highlight. Thank you.
That's what the President has said. That's what he has said.
Okay, thank you.
So I have a question to my friend on a different aspect. Now that you are a member of the committee and you belong to a party which, or you yourself feel some of the provisions are really arbitrary or whatever it is, as a party, would you like to challenge that in the Supreme Court to say these are ultra violent?
No comments. Prasad, I think your comments are very well taken. I think the association should certainly pass a resolution because it's going to be chaotic, profusely chaotic. I mean, 1st of July is barely 2 months, 2.5 months. So at least we need to have a window of 2 years to educate all the stakeholders. And this is why I'm so grateful to Bar Association of India for choosing this theme. And I think this should not be the end. This is rather the beginning. And BAI should have this consultation and this capacity building across the country, and particularly in the district headquarters.
So please. Yeah, please do.
This is a question to Mr. Dave, both Mr. Dave and Mr. Sujit Kumar, regarding the new law. Will there be any threat to our country, security threat to our country with this law? And the second question is to Mr. Sujit Kumar especially regarding the cyber crime like online fraud and transferring the money to the bank account. And when the police goes to the accused person's bank account verification to the address as given by the Aadhaar card. On the Aadhaar card or PAN card, but they don't find that the address is now not found because the bank accounts are being opened based on these documents like PAN card or Aadhaar card, but they never go and verify like the passport people, they go and verify the address, residence. So what is your take on that? Because you are
second question, my friend has answered that probably there is something in offering so far as the cyber crimes are concerned. But the first question is answered.
Sure. Thank you.
The first one was regarding. Can you just briefly could you repeat the first?
The first question is whether there will be any security threat to our country by this law, introduction of this law.
I don't see any connection between the BNS and India's integrity, sovereignty being affected. To the contrary, I think now with Section 113, Section 152, I think it would be rather more beneficial for the law enforcement agencies. I mean, I'm not justifying everything or all the definition that's there in Section 113 and 152. But I think I don't see why you see that there is possibly a connection between this new legislation and its impact on India's security. I think that connection isn't there, simply isn't there. And regarding the other one, yes, a comprehensive legislation is in the offing that will replace the IT Act of 2000 and a few other acts. So it's likely to be called the Digital India Act. So let's wait for the draft bill.
be Digital Bharatiya Act, not Bharatiya Digital. Digital भी नहीं word होगा, कुछ और होगा. I don't know. I don't know what is Hindi. Nobody knows about it actually. Yeah. No, certain things you still use in, even when you're speaking in Hindi, normally you speak English words into it because you don't have substitutes for it. My friend has asked me a question, what is the Hindi of railway station? I don't know. Viram Sthan. What has Agni got to do with Agni? Is fire. We have Stephen. So please, thank you so much. Since he has to go, we'll give him leave and give him a big hand. No, we understand you. We are grateful to you for having come and answered all our questions. Thank you.
And please do something for all these.
I think as a party they should file a petition to say they should not be made operational. We have now Dr. Uday, the most dynamic person who will give you many new aspects of it. He was getting ready all this time.
I was worried and I was waiting. मेरा नंबर कब आएगा, मेरा नंबर कब आएगा, आखिर आ चुका है. कई दफा हम वकील दोनों साइड से प्रिपरेशन करके आते हैं. Since the earlier three speakers have pointed out some shortcomings of this new act, to make it more balanced, I am bound to tend towards the plus sides of this legislation. The object is to have a balanced analysis of the legislation. And therefore, while preparing my initial notes, had it been a batsman at serial number 2, I would have started with the criticism. When I am a second last batsman, then I am bound to look at the performance of the earlier three speakers and then change my style, the points, and then the presentation. And therefore, let us go back and find out what the earlier speakers have expected from the person like me and our session coordinator. Our session coordinator made a reference that we are having some similarity, and that is within the framework of the Advocates Act. He made a reference to section 6 and 7 of the Advocates Act 1961, and that lays down different functions of the State Bar Council, that is under section 6, and functions of the Bar Council of India under section 7. And what is common between section 6 and 7, that is to promote and support the law reforms. And therefore, our session coordinator, Mr. Tripathi, was absolutely correct. No doubt, as a Bar Association of India, which was established prior to the enactment of 1961 Advocate Act, but this topic is essentially with reference to the promotion and support of the law reform. Now somebody may say that, can you call it as a law reform? The answer would be yes. The law reform, it takes some time. We are aware that it is yet to be implemented. We are also aware that in the month of February, a petition came to be filed before the Honorable Supreme Court of India, challenging these all three legislation. And rightly the Supreme Court said that it is a premature petition because The act is yet to be given effect, and therefore there is no any cause of action for coming to the Supreme Court of India at this point of time. That happened in February. Absolutely correct thing. Now the question comes that if we are saying it as a reform, then we will have to change our angle. We will have to change our approach. Let us go back to the law schools. In the law school, if we ask a question to any young lawyer or any young law student, what you would like to become? The person will say that, sir, I wish to conduct 302 matters. I would like to go to the Supreme Court of India and practice there. I wish to practice in the High Court. We are aware that these are the common stereotype answers. Not a single law student you will find who says that, sir, I wish to have my career, or I wish to enter into a legislative draftsman skill to be implemented. Now we are also aware that if you ask to any police personnel, kaha duty karna chahoge, where you want that you should be posted, he or she will say that Thana, because that station in charge is like a chief justice of that particular police station. He will not say that let me go to the local intelligence, let me go to the side branches. On the same line, if you ask to the honorable judges, what you would like to do? The honorable judges will say that I'd like to be the magistrate, so that he is a king of that local area. The honorable judges will not say that I would like to go in the parliament, in that legislative drafting department, or a secretariat to prepare a law. And therefore, if we scrutinize different legislations, then perhaps we can scrutinize this legislation and categorize this as post 2014 legislation. Now you may say that what is this, something new? When we were in the law schools, we were told that there are two groups of the legislation. One group which is a pre-independence, another is a post-independence. Slowly, after 1991, after liberalization, we were told that no. Now, post-independence, now there are two more other categories. One is pre-1991 legislation, post-1991 legislation. We are aware about the liberalization approach which was adopted by our country. And now perhaps we will have to scrutinize the legislation and brand it by saying that this legislation is pre-2014 or post-2014. I am sure somebody will criticize this also. But as a student of law and as an impartial analysis, perhaps we will have to consider from that angle also. If we are considering this as a reform, then of course the question will come whether it is the right time to criticize. The answer would be no, because we are yet to test this. Unless this legislation is actively utilized by all of us, I am sure we will not be able to find out the actual drawbacks or the plus. So what exercise we have done? The all earlier three speakers, the learned speakers, have contributed based on the enactment, based on the legislative drafting which has come to us. We all are students of law. We are aware that at least 1 decade, 10 years are required to settle the different permutation combinations which you are going to advance in the court of law. कम से कम 10 साल लगने वाले हैं for the purpose of settling those issues. Now therefore the question comes that whether it is a premature comment on our part. The answer would be no. The comment will have to be treated as a welcoming comment for the purpose of making it more better, more useful, more litigant friendly, more citizen friendly. Unfortunately, what is an apprehension? The Honorable Speaker Amit Desai, senior advocate from my High Court, namely Bombay High Court and the Supreme Court, he said that another 100 years will take place, 100 years will be required to settle the different issues arising out of this. Senior advocate from the Supreme Court, Siddharth Dave, my neighbor, he said, no, 25 long years will be required. I am saying that wait for 10 years. Within 10 years, we will come to know whether this post 2014 was actually reform or whether this post 2014 was in the backward direction. Now, having said about this, now let me go back to the another moot question which was asked by all of us. All of us got that particular three set of the new act. As a young student or young student in the faculty of law, we must have opened it. And after a few minutes, we must have closed this. It's a bare act, उसमें कुछ ज़्यादा नहीं है अंदर. And we must have put it in the bag itself, saying that okay, बाद में पढ़ेंगे, देखेंगे. Now question is going to be whether we are ready to face these different new challenges. Perhaps the answer is no, and therefore such kind of exercise is required. Honorable participants raised certain questions. Whether the police are trained, whether the judges are trained, whether the advocates are trained. I am saying that let us go to the root level. Root level is there is a subject by name civics in the school, or maybe in the law school if you go there, which is that topic which is required to be taught, and perhaps therefore it will be absolutely correct in passing a resolution that instead of 1st of July 2024, defer it by some more time so that this topic can be taught in the law school. This topic can be included in the school education. This topic can be included in the different judges training academy. This topic can be included in the administrative training academies, so that the entire implementation will be a citizen friendly. There is an apprehension which I must say. The apprehension is this, that this is going to increase number of litigation. Number one, the litigation at appellate level. Number two, litigation at a revisional level. Number three, litigation at the Honorable High Court and the Supreme Court level. Why? Because we apprehend that the Honorable judges, the police personnel, and perhaps the lawyers are not well trained, lawyers are not educated how these provisions are required to be implemented. And therefore, if we start from 1st of July, as rightly asked by our President Prashant, what is going to happen on 1st of July? 1st of July, there will be a flood of different types of the litigation. Therefore, the question comes, are we prepared for this? The answer will be no. Having said about this, now the question comes that whether we have missed an opportunity, the opportunity to include something, and what was that inclusion which ought to have been done. I'll have to make a reference about that. There are some provisions which are duplicated. The earlier speaker, the member of parliament, he made a reference about some provisions which are duplicate in nature or overlapping. So that was an opportunity perhaps which can be cured before 1st of July. To give an illustration with reference to the adulteration in the food or drink, there is a provision in the Indian Penal Code. I am referring about the earlier one, 272, 273. If we go back to Food Safety and Security Act 2006, there is a section 59 which is virtually overlapping. These are the examples which are already in the field. We will have to correlate these overlapping and make an appeal that please remove such overlapping. For example, the Drugs and Medicine Act 1940 section 27 is overlapping with section 274 and 275 of the Indian Penal Code, which is continued even in the new act. So therefore, about the food adulteration of the drinks or the food, the provision is there. Like Drugs and Cosmetic Act, the provision interlap even now. If we go back, if we go to the further, the 374, unlawful compulsory labor, like a bonded labor, the provision is there, 374 of the Indian Penal Code, which is continued even under the new act. And what is the corresponding act? The Bonded Labor System in bracket Abolition Act 1976. So again overlapping is there. So at least I can give you 5 or 6 such overlappings which can be cleared before 1st of July. Otherwise, as the earlier 3 speakers said, that because of this, the discretionary power whether exercised in this manner or that manner, there will be a rise of litigation. Whether this act will prevail or that act will prevail, there will be a further litigation. On this line, you will find, with reference to the rash and negligent driving, and Indian Penal Code 279 we are aware. But Motor Vehicle Act 1988 section 184, again that provision is continued. The same provision of 279 is continued in this Nyaya Sanhita. So therefore at least 5-6 different things are there in respect of which we lost an opportunity, is a humble opinion. Because this could have been cleared. Apart from that, you will find that there are certain omissions which have been made. Those omissions are specifically with reference to the particular topic. Now those omissions, whether right or wrong, the time will decide, because those omissions are yet to be tested. Like adultery. The earlier speaker made a small presentation in which the adultery word was there. 497 of the IPC. In the new act, it is not there, but there is a reference under 498A. 498, not A, 498. So you will find that the adultery, which was a offence under the old Indian Penal Code, is now done away and removed under the new Sanhita. Unnatural intercourse, section 377 of the IPC. We are aware that with reference to decriminalization of those consensual relationship, the judgment came from the Honorable Supreme Court of India. But under the new act, you will find the rape on the male or intercourse with the animal. These are the things for which now there is no offence. As a result of that, despite the new act, there is still a vacuum with reference to certain types of the offences. Now you will also find the molestation of a woman, section 509 of the Indian Penal Code, that has been omitted. Now 509, whether correct or incorrect, that is something different argument. But the law has been made, the new Sanhita says that the priority is given to women and children. Separate groupism has been made with reference to those offences. Despite that, this 509 is now omitted. Whether it is correct or incorrect, time will decide. You will find that lurking house trespass at night, 444 of the Indian Penal Code, or 446 house breaking at night, those have been removed. Now whether it is correct or incorrect, time will decide. You will find 309 has been removed, attempt to commit suicide. Now there are several such provisions which we can make a list. Now with reference to the weights and measures or Indian coins, there were several such sections which have been removed from the new Sanhita, like section 264 to 267 of the IPC. Those were with reference to the weights and measure. Likewise, with reference to the coins, Indian coins, 236 to 238 of the Indian Penal Code. Now the time will tell us whether it is correct or an incorrect decision which has been made. Having said about this, now the time has come to make a reference about certain new concepts which have been introduced. The young participant from the Odisha made a reference, and that question was asked to the learned MP, member of the parliament, and at that point of time, the honorable chairperson will recollect, I said that two speakers are yet to start their batting and the question has come, and that was about the theories of the punishment. Let us go back to the schools. In the law school, we were taught about the theories of the punishment, and in the Indian context, we are aware that deterrent theory of the punishment was the only theory which has been implemented all throughout. From 1860 till today, most of the section you will find that deterrent theory of punishment has been touched. The reformative theory, of which some sections may be having some reference, was still not implemented successfully in the Indian context. Now we can say that with reference to introduction of some more reformative angles, this theory may get a further push in the Indian context. This is with reference to that community service. The Honorable Speaker, Senior Advocate from the Supreme Court, Mr. Dave, asked a pinpointed question whether community service is defined under the new act. Of course, the answer is no. But the fact remains that this is a enabling provision which is available to the Honorable Judge the judge will utilize that. The judge may take into consideration the mitigating circumstances. The judge may pass appropriate further order. Now something good is the organized crime, terrorist act, these have been defined under the new act. There has been a demand for years together saying that why do you have different new legislations? Why don't you incorporate those provisions in the mainstream, namely the penal code, like when Makoka came at that point of time, Tara, Puta, why do you need that? And the logic which was cited before all of us was this, that because of the complexities of the offences, there is a need for the further legislation. The further legislation which is stringent, and therefore the legislations were introduced. Now this is something new which has been attempted to, namely now organized crime has been defined. Now terrorist act has been defined. On the same line you will find with reference to the transgender, there is some reference in the new act. About the gender neutrality also, some provisions are there, though it has been a demand for years together. Having said about this, now the time comes to find out whether we are really speaking ready to meet these challenges. As I said that this enactment has to be a citizen-centric enactment. The young lawyer asked a question about the victims. Somebody may say that no, there is another different angle. But the fact remains that as on today, the new enactment has to be a citizen-centric. And the question before all of us is this, whether this act is going to achieve that particular target. Now, having said about this, as I said that we are student of law, and in view of that, I am also open for correction. And as I said that, since all earlier my three speakers, they said that they started by criticizing this act, therefore I was required to change my presentation. I was given 20 minutes, 13 seconds, 14 seconds, 15 seconds. Now it's a time to stop, and I am open for the question and answer session also. Thank you for the opportunity. Thank you once again.
Thank you, Dr. Uday, for the new prospect. You brought us back to the positivity from negativity. Yes.
Sir, there is one more speaker. After that speaker, if the chairperson permits, I'll try to answer this.
You can answer now also.
Now also. Why not? Sir, it's a long journey. It is going to take some more time. We'll have to pass the resolution as our president said. We'll have to push it. See, the rest of the India is looking at BAI. They are expecting some guidance. Though this is getting recorded, there is a disclaimer. The disclaimer is not to expect from the statutory authorities. So therefore, this is my personal opinion that the rest of the India is expecting some guidance from the Bar Association of India, and therefore at the end of this entire 2 days rule of law convention, we will have to make either request for extension of the time. In the meantime, some steps to be taken, and in addition to this, fill those gaps which have been pointed out by different speakers. I am sure other two sessions are there in which these gaps will be pointed out. The shortcomings will be pointed out. This is that scientific exercise which was missing, and we are doing that. So therefore, this recording or these notes which are being taken, that will be useful for the purpose of making a very effective representation to the minister and the government. I am sure they will consider it in the positive angle.
I thought as a Bar Association of India, you as a Vice President would suggest that we should file a writ petition and ask the court to stay it.
Had it been a pre-2014, I would have suggested this. because now there is a tendency to agree with what the government is saying. And most of you agree with this agreement that honorable judges agree with what the government is saying.
But you must create an exception, I thought. So we have Dr.
President-elect may direct, we will do it.
Let's call Nariman back from the heaven.
That's right. So let's now hear Dr. Anita Pujari, her concluding remarks, what she thinks. Maybe she is able to give us a solution what Bar Association of India should do.
Thank you, Chair. There is a dilemma where to begin, because most of the speakers have already spoken about a lot of issues that was there in my mind. They have all expressed the concerns that we all have, because when the law was coming, we knew, and the debate had already begun in the country, that there is nothing new that's coming. So therefore, even during the lunch session, somebody from the audience asked me, Madam, itne speakers ko sun rahe hain aur pad rahe hain, lekin nothing new is emerging. Because if there is nothing new would emerge. So that's one side of the dilemma. Coming back to where Sir left, that what can the Bar Association do? Maybe we can begin from there. Bar Association of India in the past had always taken the lead in taking up causes that might be unpopular, but had taken it to court and challenged. Just yesterday, I was reminded of one of the intervention applications, which is not very well known, because the NJSC fight that we had and the foreign lawyers entry that we objected on the ground that unless there is reciprocity, Bar Association India will not welcome. So those cases we do remember. But just yesterday I came across one of our during COVID applications that we had filed as BAI, wherein I had filed my affidavit, was whether the high courts should exercise their jurisdiction under 226 and 27 during COVID times to listen to all the matters, or there should be just barrage of suo motos in the Supreme Court. And the debate went on, and I do remember that Bar Association did intervene in the matter, and we had filed an application saying let the high courts decide. So the cause might be difficult, the task might be tough. We have not bothered for the answers that we have got, but if it is a fight worth it, then we have gone for it. So my answer to, or the response to the query that came from our own treasurer is this. So therefore, if it is worth it and the House feels that we must, then we must. Now, listening to all of you, as well as to the questions that were coming up from the audience, one thought that came across was, one of my favorite quotes from law school days is the quote from Cardozo, who said the life of law is not logic but experience. I was just wondering, did we, while enacting this law, take that too seriously? To only take the first part of it, that life of law is not logic. Did we forget or did not emphasize enough on the second part of the quote, which is but experience? Because what has happened, what is emerging from the discussion in the House today is probably there were, in the last more than 100 years that the IPC got enacted, and the rationalization process that took place, because when our president was saying that it took 100 years to understand these provisions, that means there were random provisions. We never know what was the debate and discussion in 1860. We went there, but there were provisions that were formulated that stood the test of time. That stood the test of time precisely because we as lawyers and as society understood certain governing principles in a certain way and decided to define the societal life in a certain way. For example, just to give an example that immediately comes to mind, for example, the idea of the lynching, probably it wasn't there that prominently, or probably it was there, but it wasn't in public forum being discussed and debated that much. So therefore, when it came to the forefront, the matter went to Supreme Court the lead matter being Tehsin Poonawalla, the Supreme Court did, pass certain directions, and it so the state governments also took certain steps, and the matter is still pending for compliances. It gets listed from time to time to ensure that the compliances take place. So there are situations whenever we are talking about law reform, going back to what Mr. Varunjikar was saying, that whenever a law gets enacted or formulated, either there is a demand from society to look at it that we must address a certain situation, or we ourselves, we realize that the working of a particular law is not that good enough, and we have got certain experiences to incorporate, and let's go for it. So there has to be some demand. So far as BNS is concerned, it looks like probably there was no demand for it. So if there is no demand for it, and one doesn't know where we are heading to, there are possibilities of mishaps, which looks like it has happened, because so many of the provisions, when Mr. Desai in the morning was giving example of how many, he was giving the statistics really, how many provisions are changed, how many got compressed, how many got deleted, reduced. It was actually not giving a very good picture, because the number of provisions merely getting compressed might lead to confusion, as my previous speakers have said. So therefore, going back to Cardozo's explanation of whether we forgot the logic, and we might have, it looks like we might have forgotten to incorporate the experience that we had over the years. If that is so, the scope for change still remains in terms of how it is interpreted, but keeping in mind the fact that we are talking about a criminal law. We are not talking about a social welfare legislation where the scope of broadening exists, to my understanding, but it is not an impossibility as well. Now, going back to my own experience of dealing with some of the provisions of IPC and how we were able to deal with it successfully, I was so happy sitting there in one corner. I was actually smiling, because some of the provisions which I had challenged through various petitions now stands recognized. They are no more there, and each and every speaker in today's panel was actually celebrating that. For example, when the matter of independent thought happened in Supreme Court, I was very much part of that litigation, and to see for the first time the Supreme Court of India reading down a criminal law provision was a rarity. One would not imagine it. It happened. It happened. Where, because there were so many laws that were existing, the child marriage restraint and prohibition. We all know for the last 100 years there are laws in this country by which child marriage is prohibited. Despite that, we know of certain occasions, religious events, where child marriage is quite prevalent in some states. It was happening. We had the data. When all that was shown to the court, the bench led by Justice Lokur, did not hesitate to read down a criminal law provision by which, if it's a child marriage and the wife is a minor but she has been sexually exploited, then he did not hesitate to read down and say this can't be an exception. In fact, so far as marital rape is concerned, when independent thought was getting decided, I very vividly remember in court number 4, somebody did refer to the fact that the marital rape challenge is pending in Delhi High Court. It was mentioned to the court, oh, you don't decide even this. That was also proposed to the bench, that you don't decide so far as the child rights exception is concerned. Let it be as it is, because we need to save the institution of marriage. Because we need to save the institution of marriage, so even if it's a minor child, girl child who is being sexually exploited, let the IPC exception be there. It's not a rape. It was brought to the notice of the court, but the court did decide otherwise. Although leaving the scope for interpretation so far as marital rape is concerned open. It said since it is pending there, as and when it comes, let it be decided. So there are always possibilities, although in criminal law, as we know, the possibilities may not be as expansive as we find in other laws, in social welfare laws, but it exists. But again, similar is my experience, at least as a litigating lawyer, with regard to decriminalizing adultery, and as well as 377 and 497. Each of the speakers celebrated it. These were challenges that we took to court. So therefore, there is always a possibility of an act getting challenged, provided we do our homework of putting it in a way that we can prove that it violates our fundamental rights or there was no competency to do so. Therefore, as well as NJSC, it was a big, huge challenge. In fact, it was a post-2014 law. Just for all of us to remember, it was a post-2014 law which we had challenged and we succeeded. So, these are some of the celebration, my own personal celebration I would say, where we are talking about 377, 497, overwhelming recommendation of the committees to reinstate. It did not get reinstated. So I think congratulations for that. We need to celebrate each one of these successes for the simple reason, more than enacting a law which leads us to chaos, it is important that we do not undo the successes that we have already had in court of law after fighting for a long period of time. So I think this is also, the celebration might be small, but it is worth it because each of these steps has helped. So for me, it's a personal success in 3 of the matters which are not incorporated. So therefore, it also gives me a very strong signal. And you know what the signal is? That the system of separation of judiciary and executive and the legislature is robust to the extent that our criminal law is not interfered with. I'll tell you, every time a law is getting enacted, the judgment is coming. We also find examples very frequently where immediately laws are being brought to actually ensure that the judgment is nullified. But here is a situation where judgments are not nullified. There is suggestion to nullify, but that stands rejected. So I think this is time to celebrate that. And the robustness of the institution, to whatever extent it remains, it's time to remember that. Now, however, going back to the first of my submissions, that probably we forgot that there should have been logic to whatever we are doing. Because when I look at the title, as the learned AG in the morning said, oh, look at the wordings that are used, the phonetics, the semantics, so to say, of the title. Now the semantics suggests to me that, oh, we are going to talk about Nyaya, which stands in contradistinction to penal provisions. If it is so, then where is the logic of the punishments? Because when I analyze some of the provisions, for example, we jokingly in our office we were talking that there is some one in 1860s Act where if you possess certain amount of money and you don't give notice that you do possess, then there is a punishment. Under that law, the punishment is imprisonment for 1 year. Now for offences like assault, criminal force, that also carries punishment of 3 months. So there is no logic as to, even for seriousness, the seriousness of the crime and the punishment that is now provided, I can't see logic in many of the places. And that is so far as section 131 is concerned, that is just an example of it. For example, flying kite can dangerously can lead to a prison term of 2 years. So the punishment for offense of money laundering, for example, and assaulting using criminal force with intent to disrobe a woman is the same. Now I again do not find any logic in that, which is minimum term of 3 years, which may be extended to 7 years. Be that as it may, there are areas that we must look into, because this was a golden opportunity for us to see that the punishment and the crime, they actually go in a manner that justice is attained. Probably we have lost we lost our lanes somewhere and we did not align them properly. There was another great opportunity for us, as my previous speakers also said, about aligning a number of legislations. Probably we also could not fathom everything, and we could not align them together. Some of the examples such as the Motor Vehicles Act and other legislations was referred to by my previous speakers. Interestingly, there are also provisions I find that we did not recognize the changing times. For example, as a lawyer who does a lot of lawyering on women's rights and child rights, I find it so problematic that the provision on abortion, for example, which was there in IPC, finds place, it's ditto in BNS. There also the women's bodily autonomy wasn't there, even here it isn't there. Because here also it says, a woman, even if she goes through the miscarriage herself, she is the one who is to be blamed. Where is the women's bodily autonomy recognized? Whereas we have actually gone through a long round of litigations. We all know how every time when the law permits for certain weeks within which one can abort, and beyond that then we rush to court, and if the court hearing gets deferred even by a day, then how we suffer. And we also very clearly remember the case that came from Chandigarh, where Justice Balakrishnan's famous lines that the nature mother will take care of the child and the mother. So some may hail it as to be something that saves two people's life, but it's also time for us to think whether the mother nature would also take care of the daily needs. If not, then probably it's time that the woman who has to bear the child and give birth is given some independence. So far as my thought process of delivering a child is concerned, the bodily autonomy need of the women needs to be recognized, which unfortunately we did not in this round while we were legislating BNS. There are also, but there are certain positives. My friend from Odisha, she mentioned and talked about counseling, maybe cruelty, maybe mental cruelty, people going into depression. I must tell you that so far as mental cruelty is concerned, under the DV Act it stood recognized. So there was a change that had happened post IPC, which now stands recognized in BNS. So therefore now the definition of cruelty also takes into consideration mental cruelty aspect, which is a positive development, because that was lacking otherwise, because the understanding that mental cruelty can also be a cruelty wasn't there. Thankfully it is now there. There are also provisions which talks about the disclosure of identity of victims of rape, which is a welcome step, because there were similar provisions in POCSO Act, that if by directly or indirectly, if the identity of a rape survivor or the victim can be tracked, then of course it is a punishable offense. Similar provisions have been made here, because in the absence of it, if you all, I think you'll all remember the Kathua case, how it went on. The matter went on in Delhi High Court for a long period of time, where all the media houses had disclosed the face of the child, and the child wasn't even a rape survivor, she died. So and the right to dignity of a dead person was that also came in question, and I happened to be part of that litigation as well, and we had to submit to the court that the right to dignity of a dead person needs to be protected as much as you protect the dignity of a person who is alive. So therefore protecting the identity of any of the survivors of sexual violence, if that stands incorporated in the new law, that's a welcome step, and we must welcome that. Besides that, there are also there are certain laws that have actually been simpliciter copy pasted. In fact, I am not going into actually the text of it. While sitting there and while each of the speaker was saying, it was as if a learning in progress. Whichever speaker was referring to whichever provision, we were looking at the comparative analysis, and especially since I was focusing on the women and child part of it, I was seeing that it is just ditto. Even 509, now it's 60 something, it's there. So it has simply been copy pasted without realizing that the situation could have improved. But without much complaint on that, because as lawyers we know there are still scopes for improvement, and no law is the gospel truth. And therefore, I would rather believe that, for example, why I say so is in the context, for example, in the context of transgender persons. Now again, all my previous speakers spoke about how the law was said to be gender neutral and how we thought of incorporating all of that into the law, but how it has failed. Because there are certain provisions where the gender neutrality has been incorporated, but there are also provisions where we have failed to incorporate gender neutrality. Especially the provision with regard to the transgender persons has not been addressed at all. In fact, when the Transgenders Act came into being, even the validity of that is also under challenge before the Supreme Court as on date. It has been challenged by a transgender activist. How do you define a transgender? How do you determine that somebody is a transgender? The sex determination, the operations, processes that take place, all that is also problematic. Not that just because we have got a Transgender Act, that takes care of everything. Even those provisions are problematic and it is under challenge right now before the Supreme Court. However, one of the main concerns whenever you interact with the transgender community, at least I have interacted and I have come to the conclusion that the prevalence of sexual violence is there and we need to address. Similar is the case of the LGBTQI community, but that has not been addressed to a larger extent. In fact, we recently faced a situation like that when we were trying to have a relook at the sexual harassment prevention laws that are prevalent in Supreme Court, and how do you take care of all these communities, those who are finding new voices and needs to be taken care of. Because unless the parent legislation stands amended, as we saw, it is difficult. The alignment will not happen. For example, if something is specifically gender specific, addressing a women's issue, and that has not been amended, you simply amend the BNS provision, is not going to help. Because, so therefore, probably there was a need for much more alignment and thinking through. That somewhere is lacking. However, as I said, that no law is a gospel truth. Therefore, we must learn how to live with it, and if we find it problematic, how to challenge it. Because I will end with a humorous note. I just hope nobody takes it seriously. Law must never be a gospel. Today's law may become tomorrow's crime. Today's crime may become tomorrow's law. So better stay safe, better take the middle path, and if you find it too problematic, do not hesitate to challenge. That has been the principle that BAI has stood by, and I would rather stand by it. Thank you.
Thank you so much. In fact, the way you have presented it, everything changed. But I was only wondering why after what you said, that if you want to amend many laws, then why it was already Indian Penal Code. Code could always be amended to amend many acts. You could have eliminated all those acts. Those acts remain there and you have made a new act. So that conflict itself will take a lot of time to be clarified. Which act will prevail, which will not prevail, the central legislation, that is state legislation. But having said that, we'll wait for tomorrow, then we'll see what resolutions we pass. And I'll request Prashant to say a few words before we end the day.
Thank you, sir. Yeah, just before the dinner, one of the ideas which is there, yes, the law has many lacunas and we can have different approaches. The approach starts from passing a resolution and bringing it to the present government's attention that it needs some further working is one approach, and it should be the first step. And we will have discussions tomorrow also, as the chairperson has said, and try to formulate that. The second is that sometimes as law has to work itself out, Uday was pointing it out. But here, I have been working in certain jurisdictions, and there is a big difference here. There are jurisdictions which have undergone through civil unrest, through war, countries have become independent, and there, you have to start, wherever you stand, you have to start running from there. So that is where this kind of approach is there. You bring a new legislation, a new constitution, you bring a new framework, and as the country grows, it will work it out. Here we already had a system. The law may be pre-colonial, but it was honed by an independent judiciary post-independence, and a very robust and intellectually advanced legal profession and legal minds. So all these things already existed. Now, of course, there has to be evolution, there has to be change. Things cannot be stagnant, and there has to be experimentation as well. But as has been the approach earlier, the legislation, the act itself may not be stayed if the date of July 1 is there. New dispensation wants to, because there will be a new dispensation. First, because elections are going to be there on July 4, results are going to be there. There will be no dispensation on July 1. So, 4 June, sorry. So 4th June, there will be just a new dispensation coming into this thing, being formed, portfolios being given and all. How much this will be looked at. So we may have to ultimately, as Bar Association of India, go to the court. And our first entreaty to the court has to be, please hold the implementation. Because we are not ready. We are not prepared. There are so many things which are to be done. The courts itself, through judicial academies, have to train. The police is to be trained. The citizens have to know what is the new offense. We can't live in the old era of, that knowledge of law is to be deemed as taken and ignorance of law does not matter. You have to abide. So, let us take an effort which is collaborative, which takes the discussion forward, which points out the gaps, deficiencies, along with strengthening elements. What are the suggestions which are there to cure it? Just to criticize an initiative is no good. We must come up with the solutions. We must come up that these are to be the alignments. We have to come up that these are the solutions which we propose but need to be debated. And that is another ground for holding the implementation of these laws. So there are several welcome elements here. And if we criticize and put in dustbin everything, no reform, no advancement will ever happen. Because law, loves and covets certainty. Anything new disturbs it. But then, advancement has to be there. So let us at Bar Association of India, we are non-political. We stand for the rule of law. We stand for the human rights, how, citizens have to be protected from any kind of tyranny from the government, their fellow citizens and all. So we have to work on this, and we have to develop a language and a discourse in our submissions which is collaborative, which is constructive, which shows that we are an ally to anything forward-looking. We are not a drag, and at the same time, we have a reservoir of excellent minds who can contribute for strengthening the legislation and filling the gaps. So I will request all of you to be free to send your thoughts about anything in these 3 laws. In this limited time, not every one of us can actually speak, discuss, or even formulate. Sometimes we go back and we clarify our thoughts. So I invite all of you to please feel free to send on email your suggestions on info@barindia.in, and let us not hurry to have a resolution tomorrow evening, except a resolution which says that we will do this, and then leave it to a few people to take from the discourse from all of you and then formulate something. So I think today we are starting this collaborative discourse among all of us, and we will take it forward. Bar Association requires your contribution, your ideas. Thank you.
Can we take this issue to the different states and have programs in those states so that this collaborative approach can be carried further and then we can invite further contribution. Bombay Bar can take a lead. No, no, sir, from this angle, BAI and Bombay Bar, or Rajasthan wale, Karnataka wale, Orissa wale. See, this is not something adversarial. We wish to make a better system, and therefore maybe in tomorrow, correct, suggestions and solution both. See, we all are aware there was no effective debate about this bill. So we can have a debate, get it recorded, and then based on. Correct, correct.
Thank you, everybody. There's a hot tea outside waiting for you. So you must have that. Relax for some time before you join.
Dinner is in the lawns, which are just at the entrance. You have to turn left. There will be a standing of Bharatiya Association of India. There's dinner and drinks. So please stay back. Those who live nearby can have a quick change. Others can have a good discussion, a walk around, and we are there with you.
Thank you, everybody.